Good morning, afternoon, evening, ladies and gentlemen. How is everybody out there in the listenership and the viewership of AllPointsTV.com? I'm George Moss, host of the program that comes on at 2 o'clock. And we hang around every Monday from 2 to 3. And today there's a double treat because we're going to be preceding the program called Satura's Black History Corner that comes on at 3:30. And it hangs around to about 4 o'clock. And so we're looking forward to that after this program comes to a close. And of course I rush home every second and fourth Mondays when they come on and watch it live in my office so that I won't miss anything. I close the door, turn the phone off, and then I'm ready to go. Hope you're ready to go here. We're going to be talking about a couple of topics this afternoon. One of them is the situation that deals with Benjamin Carson's comment. And I brought the Constitution in so we can talk about it from a constitutional standpoint. Because I don't think these comments about that he made about Muslims being presidents of the United States, I don't think this is a controversial comment. And I want to look at not just what everybody's talking about, which is Article 6, Paragraph 3 of the Constitution. I want to look at some other parts of the Constitution as well. And want to go into Article 1 and also Article 2, and I'll tell you why that's also problematical. Sometimes you have these persons making statements that are not politically correct, and everybody just begins to fall all over themselves and almost in a faint. Because I don't think we're used to hearing anymore someone that stands up and tells the unpolitically correct truth. And we've been politically correct, I don't know how long it's been, but we've been politically correct for a while. And when you are practicing anything that has an adjective onto the noun correct, then that modifier, adjectives modify nouns. And so when you have this modifier on the word correct, then the modifier changes the meaning of the word. I mean, a modifier modifies the meaning. So I learned that in 3rd grade. You had to learn that in elementary school. And so I listened to all the comments being made, and you pay attention to the news, as we have to do here at the studio, in order to come here and be conversant on the network. But when someone says something that is true, and you see people going off and everybody's upset about it, nobody can tolerate the comment being made, and they vilify the messenger. The messenger is just bringing the message. It's not that he's creating the message. He was talking about the constitutional disallowance of a person becoming president. He didn't say he was making a law, passing any new laws. I want to read something to you in the Constitution that I think makes his point more coherent for those of you out there that are gnashing of your teeth and making all these exclamatory remarks. Let me read. Let me read Article 6, Paragraph 3. And Article 6 only has 3 paragraphs to it, so let me read that very carefully, and let's see what the language calls for. Let's see what the language calls for there in Article 6. And then we'll see if Mr. Carson, the brain surgeon, we always compare people to brain surgeons. We say, it didn't take a brain surgeon to understand this, this, and this. So I think that a brain surgeon probably knows a little bit more than the persons out there criticizing. I mean, brain surgeons out there making these comments. Here's what Article 6, Paragraph 3 says. The senators and representatives, and it says before mentioned, meaning that they've talked about it above in paragraphs 1 and 2. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers both of the United States and of the several states. This is the Supremacy Clause, as you know, in Article 6. So they're saying that what is written here applies not only on the federal level, but it also applies on the state levels as well. And that was more the case with a lot of other things when they passed the 14th Amendment in 1865, which through the Due Process Clause, which only applied to the federal government in Article 5, the 14th Amendment spread that through the states, and also the Equal Protection Clause, which was now spread throughout the states. But we're talking here about Article 6, Paragraph 3, that makes it so that everything that's applicable to the federal level is also applicable on the state level as well. Okay, so it says both of the United States and of the several states shall be bound by oath or affirmation to support this Constitution. So if you have a state job or you take a federal job, if you work for the state and you're in the state legislature, for example, or if you're on the federal level and you are a representative or a senator, then this oath of affirmation must be taken. You know, they don't want to have any traitors. It doesn't mean that you guarantee that you won't guarantee there won't be any traitors. But it's kind of like taking some precautionary measures to make sure, to try to ensure as much as you can that that will not be the final result. So this applies both to the United States and the several states shall be bound by oath or affirmation. You can either swear by it or you can affirm it. Affirm what? To support the Constitution of the United States. But here's what everybody is hollering about. But no religious tests shall ever be required as a qualification to any officer or public trust under the United States. It is that part of Article 6, Paragraph 3, the last sentence in it that everybody's talking about. And they're saying, well, there's no requirement. In fact, it's forbidden for anyone to require a litmus test, and that litmus test being something that has to do with religion, and it certainly does forbid that from being the case. Let me tell you what the implication of the language is that nobody's talking about, because there are some implications. The language does have an implicit message in it, and the court, which wants to find implications in everything now, I think they would be able to go along with this implication of this language. If you say, for example, no religious test shall ever be required as a qualification to any office or public trust under the United States, then that would also mean, through implication, that no religious standard can be imposed upon the person from any other corridor that serves in that office. And what Carson is getting at, I don't think he is as technically understanding it in terms of the implicit aspect that we're talking about here. But what Carson was talking about was a requirement of Sharia law. And if you want to go on the internet sometime and look up Sharia law, you'll see there's a long, drawn-out explanation and discussion about Sharia law. And the first paragraph, what it's discussing is that all aspects of Muslim life is governed by Sharia law. Marriage, sexual activities, I mean, you name it. There's no aspect of Muslim life that's not covered by Sharia law. And so the question is whether or not this language in Article 6, Paragraph 3, would in fact put another type of prohibition about the person taking the oath of office, because if you cannot put any stipulation upon the person based upon religion, then it also would mean that you can't have someone on the outside putting a prohibition that imposes a religious claim upon the office as well. And that's a problem if you're a Muslim. And I heard an expert last week, a brilliant person that was on Mark Levin's program. And Mark Levin, who is without any question, I think is one of the most profound constitutional scholars in the country. I mean, I listened to Jonathan, this person that they have on from, I think he's from American University, and they have him on there once in a while. What's his last name? I know his first name is Jonathan. Dr. Jonathan, last name fails me right now. But when I listen to him talk about the Constitution, I really can't believe some of the things that he actually says. And I've been surprised by Judge Napolitano. I've been surprised by some things that he said, because I don't think they're reading the language carefully, particularly when they start talking about citizenship in this country and that you're automatically a citizen. Once you come into the country and you have a child, you know, you stay on the other side of the border, and you're now in your 9th month of pregnancy, and then right before the child is born, you step a toe over on the other side of the line of demarcation, and your child is now a citizen of the United States, and we got to now take care of the person for the next 85 years. I don't know where they get this from. First of all, we haven't had a test case on it. It's just some absurd legislatures, legislative members that don't know what was passed in earlier time periods. See, don't forget the 14th Amendment was passed in 1868. And the persons that passed it, I think we can all agree they're not here now. And so now what they're doing is they're going to try to discern what the intent was. And if they do that, I can tell you what the intent is. Where it won't be any problem. The intent was to normalize the citizenship, to regularize the citizenship of the newly freed slaves. They were given their freedom in 1865. Then the question is, okay, what is their status then? I mean, they're free, but being free does not mean that they are citizens. So then it was to normalize the citizenship of the former slaves. Now let me tell you what else it does, and I don't think there's any reason to be confused here, because in the first 2 sentences of the 14th, I don't have it here, I just have the first 7 articles. I can tell you what it says. In the 14th Amendment, and Judge Napolitano, you don't have this right. And what is Jonathan's last name? He's wrong too. I mean, there's only one. I don't know of any. There are maybe Dershowitz, Alan Dershowitz, but I don't know what his position is on the 14th Amendment. I'd like to hear his position on the 14th Amendment, because so many people that are scholars in some realms, and you give them a lot of credit because they are more qualified to comment than most laymen are qualified to comment. But sometimes when they make these comments in areas where there's not been judicial scrutiny and a decision made by the court as to what the language means, and we have legislators trying to interpret what other legislators did, that doesn't always get it, because they're not the interpreters of the law. The law is interpreted not by the legislatures. The law is interpreted by the court, and I wish they could learn their role. But when you go to the 14th Amendment, it says all persons born or naturalized in the United States. And then here's the second part of it. And subject to the jurisdiction thereof. Now, anybody reading the language can see that that is a very important caveat in terms of not making it a point of your being a citizen based upon your natural birth or being naturalized by being born in the United States, because it says, and subject to the jurisdiction thereof, which means that if you are born in the United States and you are under the jurisdiction of another country, even though your birth is here, because the jurisdiction under which your citizenship is claims are made, then that is an exclusion of that person being a citizen of this country. So if the mother has a child here, and the mother is the person that has her, she's under the jurisdiction of another government, then her child's under the jurisdiction of another government. When I left here and went to Europe, and I want to know where the American embassy is located, because if you get in trouble in these foreign countries, you're not gonna be able to go. You can't go in there and make an appeal to that government to defend you based on the fact that you're inside that particular state. You have to go to your own embassy to do that, because that's where your jurisdiction is. And I was in Amsterdam, and I'll tell you, my jurisdiction, and I was under jurisdiction, I'm under the law in Amsterdam, but I'm under the jurisdiction, though, of the United States. Why? Because your citizenship does not move just because you moved.
Well, that's proven because you have to still pay taxes to them even when you're not living in the country.
Otherwise, anyone that moves out of the country becomes a citizen of the place where they're landing in. That's an absurdity that I don't think, because I don't know what this court would do, because the court does not, I don't think we have a court that's actually following the Constitution, but if they are true to the language in the 14th Amendment, there's no way in the world they can sustain this idea. There's only been one court case that I know of, the one case of 1890, was it 98 or 94, one of those two. But I think it was 18, I think it was 2 years after Plessy versus Ferguson. And what happened was that there was a person that was, whose parents were here legally, had been in the country, and they were, for all practical purposes, they were here on a legal status, had been here for years and years and years. And their son, who was 20 years old at the time, left the country and came back in. But when he tried to get back in the country, because of the status question of the parents who were here legally, but had not been made a naturalized citizen. Now let me explain something here. By them being here as a legitimate person inside the country, and their son being here for 20 years and had never been anywhere else, the question is, with him never been in another place and had been under the jurisdiction as his parents were for 20 years and he had never been outside the country in 20 years' time, the question in that case, the court said that in that case, that person was a citizen of the United States, because he'd never been under jurisdiction anywhere else. His mother had been under jurisdiction. This wasn't just putting your toe across the line. And the child had established jurisdiction for 20 years. Now, when a child is born and just recently birthed, how does that child how is the jurisdiction of that child under the auspices of law and jurisdiction, under the jurisdiction of the United States, when a child can't claim jurisdiction because the child was just born? We're not talking about 20 years here. And the court made a ruling in that case, and now they're saying it applies in all cases. And we haven't had a test case on that yet. And Mark Levine is absolutely right in what he's saying there. Everybody else is saying something counter to that. Those persons are wrong. In fact, whenever Mark Levine makes a constitutional argument, I can tell you right now, that store is closed. I heard somebody on one of the network programs, this is Lori Ingram, and she was coming and they were asking her, after Mark Levine had given the sermon on the Constitutional Mount, they asked her to make comment, and she made this comment. She said, after what Mark Levine said, it was on another question, but she said, after what Mark Levine said, there's nothing else to be said about it. And that's pretty much the way it is. I mean, when Mark Levine gets into giving his constitutional understandings, I don't know of anyone that is on that level. And I'm just trying to think of this guy's name. I know he's I think he's at American University. But I know he's not on that level. He's not bad, but he's not. I wouldn't call him an expert, because when you get things wrong like this, and you're making these claims, even the claim that they're making that the Constitution does not forbid a Muslim from being president of the United States. I think it does do that, but you have to understand it's not explicitly stated in that sense. Let me read something to you here that will make the point a little bit more. I think it's implicitly true. When it says there's no constitutional test, I think that works both ways, both in terms of the law putting a prohibition against somebody's religion, but I think that there's a prohibition in terms of anything that puts a imposition upon the lack of the person's ability to fulfill the requirements of the Constitution. Let me read this to you. I'm going to read Article 1. I'm sorry. I want to go to Amendment 1. The First Amendment says that, well, what the courts did in 1948 with the Everson case, Everson versus Board of Education in 1948, and it was solidified in another court ruling that took place in 1962, the Engel versus Vitale case, where the court made it even more clear. I don't necessarily agree that the Constitution does this, but we have a ruling on it. So let's go with the court's ruling on two different occasions: Everson versus Board of Education in 1948, and Engel versus Vitale in 1962, where the court said that there is a requirement in the Constitution, in the First Amendment, which has in it the Establishment Clause, that government cannot establish a religion. The court took that language and then it extrapolated that what it means is that then government must have a separation between the state and religion. And since they made that ruling, then we have to go with that. So the court has already made it clear then that there has to be a distinction between the church on the one hand and the government. Why? Because you can't serve two masters. And if you have fidelity to one thing, you can't have fidelity to the other. And the question comes back to Sharia law. Does it require fidelity? And if Muslims are honest, they will agree it does. I will tell you, no Muslim is going to say that Sharia law is subordinate to man-made law. That would be blasphemous. And no Muslim is going to say that. If they say it, then what you have there is a certain amount of dishonesty. And I'll give you an example. Nadal Hassan. He took that oath. Was a colonel in the army. And when people write and say, well, can you, there's one guy in the military that was on Facebook, and he asked me, well, because he was trying to think about what had happened when he was in the service. He said, well, can a person that was in the military, can they take that oath, and what does that mean when they take the oath? Well, it means that they are saying one thing and they are practicing something else. And Nadal Hassan took that oath of his fidelity to the Constitution over and above Sharia law. But look what happened at Fort Hood in 2013. Hollering Allahu Akbar and going off on fellow soldiers, of which 13 of them lost their lives because of this ticking time bomb that's going on, and 30 persons were, in fact, more than 30 persons were injured in that one incident. And this idea of taking the oath, I'm saying that any Muslim that is a Muslim who is a practicing Muslim, not somebody that's talking, a talking Muslim. We have talking Christians too. But I'm talking about a person that is a Muslim based upon the fact that he's practicing the tenets of Islam. And one of the tenets of Islam, I'm not talking about the 5 pillars. One of the tenets of Islam is Sharia law. And there's no Muslim. You couldn't be a Muslim, in fact, do this. You could not be a Muslim and say that man-made law supersedes Sharia law. Okay, so let me read to you this. You see, it's not explicitly stated that there is no religious, there can be no religious test. There is no religious test. But you have to assume that the implication of the language then is that no religious test can be imposed upon it, upon the individual. In other words, what is denied directly has to also be prohibited indirectly, which is what that amounts to if a person believes in Sharia law. And so Carson was absolutely right in saying that if the person disavows Sharia law, then of course there's no problem, because the particulars of the Constitution would be therein carried out. But if Muslims disavow Sharia law, I can tell you right now that they are in fact disavowing it because of what the Quran calls for in nations where Muslims are outnumbered. The Quran calls for them to be able to lie to the infidels because of the sheer numbers that are weighted against them, so it's Quranic for them to hide their true intent behind a mask. But I can tell you right now, no Muslim is going to take the vow and say these words right here. That's in Article 2. I think it's paragraph 6. Listen to this right here. Let me see. 1, 2, 3, 4, 5, 6. Paragraph 7. Listen to this very carefully. Now, they're going to use the word he here, but we know we have women now running for president. But when they wrote the Constitution, it was not foreseen that you'd have women running for the office. So when you read the word he, understand that that language will be adjusted. I would assume at some point in the future. Before he enter on the execution of his office. Now we're talking here about the president. He shall take the following oath or affirmation. In other words, since there's no religious test, then you don't have to swear, which is a religious way of saying that I do agree. But if you're not religious, then you can affirm it. You take these 35 words. Here are the 35 words. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. I think we all will agree, some of the Constitution conflicts with Sharia law. And so when that happens, what do Muslims do? When there's a conflict in faithfully executing the office of President of the United States, and will, to the best of your ability, preserve, protect, and defend the Constitution of the United States, what do you do when there is a conflict between man-made law and Sharia law? And Sharia law is very clear about what happens. Nothing has a weight above the weight of the law that's given out by God. And that's what Carson was saying, that unless they disavow that, you see, I would be a little bit more hard-nosed than Carson. I would say that no Muslim should be allowed no practicing Muslim should be allowed to subvert the process that way, because I don't think we're talking about truthfulness here. Just like I don't think that we can talk about Muslims that are not jihadists. You know, people get confused here. They think that because not everybody's flying into buildings, flying planes into buildings, or in these terrorist camps, that one person stood up in New Hampshire and asked Donald Trump about it and said that there are terrorist training camps in the United States, and people never got around to the question the man asked. They want to talk about, well, Trump didn't defend the president. And the question is, defend him from what? If you say the president is a Muslim, when did that become a swear word based upon those who are defending the fact that Muslims are not a problem? So if somebody says the president is a Muslim, what's the problem here? Maybe the person could be wrong, but I mean, is that a profane claim that's being made? They acted like it was. Yet they're trying to say that there's no problem between the two, Christians and Muslims. There's no problem. So why would there be such a big beef about that? So my argument, my point is that to understand Islam, which how many people actually have read the Quran in this country? You know, I read the Quran.
What does it say? I mean, I don't understand why they say it's a religion of peace. I never got kill, behead, destroy, forced into servitude. I don't know if those are any of those peaceful terms. Not to my understanding, they are. You know?
John, they haven't read the Quran. That's why they think it's a religion of peace. You can't read the Quran and then come away and say it's a religion of peace. It's a religion of war. The Quran calls for going to war with the infidel. And David Cameron doesn't understand that. Letting these persons in England. Angela, I guess her name is Angela, you know, we pronounce it here. Angela Merkel certainly doesn't understand it, not what she's doing, talking about it can take 500,000 over the course of the next 2 years. Do they understand that there were Muslim nations that would not let these persons in their country because of the destabilizing influence it would have in those countries, and now they're letting them in the countries where they are totally different in their cultural orientation in those European countries? If they are incompatible in Muslim countries that were afraid to take these persons in because of the incompatibility, for example, of in Syria, you have the Alawites, which is Shia Muslim. And so these Muslims are Shia, and if you notice that the Sunni Muslims wouldn't let them in the countries. I mean, Saudi Arabia, that's Sunni. Turkey, I mean, 90% of the Muslims are Sunni Muslims. So they didn't want them in those countries, which are more alike, because they're Muslim countries, so they're more like the Shia. They have a disagreement about the line of the secession between the two. The Sunni believe the line of secession comes through Aisha, which was the 6-year-old that Muhammad married and consummated the marriage when she was 9. There's one view that the line of succession goes through what was the Prophet's favorite wife, and so the father line, that would be the line. But the other one is that these are, I think, the Abbasids. I think that's that line that it will go through the uncle, the Prophet's uncle. And so Ali would be the progenitors. So there are two different lines here, one Shia and one Sunni. So they're not compatible. In other words, Muslims don't get along with Muslims. And so they wouldn't take them in because of the fact that they have a different branch of Islam. Now, if that's a problem, Angela Merkel, if that's a problem between one Muslim sect and another Muslim sect, and you bring them into Europe, which basically doesn't have any particular sect, because Europe basically is secular. And you put them in that environment where they don't, where they don't believe in anything about God. I mean, Europe is almost godless. I mean, I know we had the Pope here last week. I'm glad he's gone, by the way. I mean, I returned to every station, they had the Pope on there. And I don't think he mentioned Jesus not one time he was here. If he did, I didn't hear it. And when he spoke before the Congress, this Pope was talking about climate change and things like that. Very political Pope. And I didn't hear a whole lot of religion and what he said. So that's a problem even there. But in Europe, and I was noticing this when I was in Europe this summer. In Europe, it's very secular. And you take Muslims and put them in that environment, and even consider the Christians to be infidels, the Jews to be infidels, you can imagine what the view is about those who are secularists, which is really what Europe is. Europe is very secular right now. I mean, these churches of England and all of that, those are state institutions now. But in terms of the population, not so much.
That's the reason why I have friends who lived in Europe who came to the United States, and they're amazed at the amount of churches we have here, and they don't get federal funding. Now, some people would argue the tax-free status of most church organizations is a form of subsidization, which I think is ridiculous. But anyway, yeah, they said that they're surprised, and they've actually found that there's a benefit actually from allowing people to come and choose their own denominational allegiance and stuff like that, where churches are basically propped up by the governments of England. I had a friend from Luxembourg who was aghast that we didn't support our churches, like that. And my mom tried to make a case, and then I think it dawned on the woman just several years before she passed away that the marketplace of values is something even allowable inside of the realm of religion. To have people come and go and choose their religious allegiances and stuff. And so we benefited from that. We had so many you got a Lutheran church down the street from a Catholic church, a Methodist churches abound. All these people contending that we're much better for that than having the state. I mean, could you imagine what the ACLU and all those other groups would be if we actually took a little bit of our money and put it towards the church? Which I'm totally opposition of too. I don't believe in that at all. But I think there's a great deal of benefit for the churches and for Christianity by not making it tied to the state. And I think that's what the founders wanted to prevent.
Yeah, I think you're very right. There is a necessity of not having a theocracy, which was the intention of the framers in terms of a theocratic-based government, because then you become a persecutionist government in terms of those unlike the religion that the state claims as its own. And so it recognized religious difference as a way of saying then the state should not get involved in that because people have different beliefs, and some have no beliefs. So I definitely understand why that was put there in the Constitution. Said that there would be a non-establishment clause of a religion in the First Amendment. I mean, that's the first thing that they did to guarantee that wouldn't happen here, because they had seen what happened in other parts of the world, and what they ran from places like England, and also from Germany. What was Martin Luther in 1517 protesting? We attacked those 95 theses on the door of the church in Wittenberg, Germany. What was he doing? But protesting the state-run operation and the persecution that was going on therein. 95 complaints about what the church was in fact doing, and that's the beginning of the Reformation, the reforming of, at that point, the Catholic Church, which was this church that Martin Luther stood up against because it had total control over Europe affairs. In fact, these other churches that were set up, I think the Church of England, let me see if I get the date right here. I think that church was set up, and I know it's 1500, 15, I'm going to take a guess here, because Queen Elizabeth would have died, would have come to power in 1558. So I think that that would have been in, I think I'm going to say 1537, but I'm going to check it and make sure I get it right, so I have it right next week. But it's in the 1500s. I think in the third or fourth decade of the 16th century, when the Anglican Church was set up as a way of breaking away from Europe, from Rome, because Rome was dictating the terms of how the rulers would behave inside their own states. And if anybody fell out with the Pope, then the Pope simply excommunicated them, and then made it so that the country was put under interdiction, and they couldn't go to service. Now you messing with people's prayer and messing with their going to heaven, you got a problem. So the king was bowing down to the Pope, and they couldn't have that. How are they looking from their people, and they are bowing down to the Pope of Rome? I mean, how do you maintain control? And so you can see that movement would lead to something very different. I'll tell you a good book to read. If you really want to read a very good book, there's a book out by DeRosa called The Vicars of Christ. The Vicars, Vicars, The Vicars of Christ, The Dark Side of the Papacy. That's a very good book. I read that book twice. I mean, some books you just really, I mean, it's so well written and so profound. You have to. I read that book a second time. I read it very carefully the first time, and I ran right through it the second time. But it's such a good read. It's like I just wanted to go and take my time the second time. Well, the first time I was very methodical, but the second time I ran through it a little bit more. But I was enjoying the style of the writing. Very good writer. I haven't read anything else by him. It's a very good writer. And he talks about the dark side of the papacy. People will be very surprised. He talks about one king who had been excommunicated. His subjects therefore mad at him because all the doors are now closed to the church and they can't go in there because the king is messing up. And therefore the king is in jeopardy. And to avoid the jeopardy, the king went outside the door where the Pope was, trying to make an appeal to say he was sorry, so to speak. And the Pope threw out more or less a knapsack for him to put on and made him wait out in the snow for 3 days to show him who was in charge. And I think that was a thing that began, when the shan hit the fan. I think it's when they realized how dangerous this was to their own rulership and what was to be a sovereign state. So that's the beginning of it there, in terms of them now saying that the Holy Roman Empire was a threat to the sovereign governments in these different states in Europe. So the separation of at least from Rome, now not necessarily the separation of church and state at that point in England, but certainly the separation of the church in England from the one that's in Rome. The framers took it one step farther and said there should be a separation of the church and the state itself. There shouldn't be a Church of England here in this country. You know, at the Anglican Church, it's Church of England. So they were disavowing that as well. So they went one step further in it. And I think that when you look at the inaugural oath, it says in Article 2 that before he enter on the execution of office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States. That means that's total fealty to the Constitution of the United States, and nothing else can take the place of that. Well, does Sharia law allow that? Go read the Sharia law.
It's actually, in my opinion, if a person really wants to be a good Christian, he or she shouldn't really be involved in politics because it does muddy the issue. I mean, I'm not trying to say they can't participate in the electoral process, or whatever, but to be involved, like back in the '80s when he had that group come in with Pat Robertson and stuff like that. That destroyed. That actually made religion now a target to people who have been basically largely ignoring it. So basically, it does money, and let's face it, a lot of those politicians that take payola, they got corrupted. It's because politics and religion shouldn't mix, and that's what happens when you look at the historical context, in not only Christendom but also in Islam.
Yeah,
you simply cannot do this. Mm-hmm. It's a theocracy. You can't.
I think there is. I think that, and I would be fair and balanced and say that I think there is a prohibition, a sidebar, indirect prohibition, because for those who are fundamentalist Christians. Because if you say that there are fundamental principles that you're going to follow, and the Constitution is saying something that's in some contravention of that, contradistinction of that, I think that a fundamentalist Christian who is Pat Robertson or some of those persons would want to impose that view, their religious view, on what really is more or less a secular document. And that would be a problem also. So it's not. I'm not trying to target any particular religion. I'm saying that there's a problem in terms of this idea and premise that's put out on two different occasions by the court, Everson case and then the case in Engel versus Vitale, that there is this separation to be respected. And if you cannot do that, then the oath is not for that particular person. And I certainly think it's the case with Sharia law, because that is a specific claim that's made in terms of it's making the statement that it is above man-made law. I'm not sure if there's anything written, and certainly nothing I've read, where there's an actual textual claim made that Christian law or some law of the Christians supersedes the Constitution. But if there is that claim that is made, I think this language here forbids that person taking office. Doesn't mean it doesn't mean they would not be allowed to take the oath of office. I'm saying if they are honest and true to their calling and then to the Constitution, I think that there's a contradiction here. That's all I'm saying. I'm not saying we're going to suppress anybody.
I just think basically a Christian who is motivated out of truly being Christian should just look said you cannot serve two masters at once. And basically politics is another master.
That's a problem.
It's a God and mammon. Basically, I mean, with that word mammon that's used in the New Testament, the most often quoted King James version is they use the word mammon. That's fitting. It is a kind of a demonic thing.
It is a problem.
Yeah, it is a demonic thing.
And we have to be honest about that in terms of that being a gray area here that has to be reconciled with the kind of nation that we're going to be. But I don't think we ought to be excoriating Dr. Ben Carson and acting like he said something that was just so bigoted that this man, which is what CARE did, this man is unfit to be president of the United States. And CARE has called for Ben Carson to step down as a candidate for the office of president, saying he's unfit. And I just think that's an extreme position, and I hope we don't fall for
if these liberals
fall for that.
If these liberals are really consistent too about wanting to keep a separation of church and state, both CARE and AIPAC should be forced to be registered as foreign agents. I think that's because they basically are. Let's face it, Zionism is tied to religion. Even if you got the secular Zionists, they are using for the basis claim from a book that it's been considered holy, and that is a religious text. The land claim is based partly upon the claim from that book. So therefore, AIPAC and CARE should be all registered as foreign agents.
Yeah, John, I think you got a point there. John, let me ask you a question. Do you think that if Kim Davis had been a Muslim and she was wearing the hijab or the kabab, Do you think that if she had a religious objection to issuing same-sex marriage license, they would put her in jail?
No, actually, I think the liberals have been falling all over themselves, going backwards, trying to accommodate her. I really do. I think I think with the liberals, it's a kind of like, this is a novelty thing. We want to see what these people are like, and we're going to give them, oh, you can't, you're just too harsh in your criticism or potential, like, you're not jumping on board. And I don't think that all Muslims are terrorists, obviously. But I don't think that, I think they're so stupid, the liberals are. They say they want women to have reproductive rights, and we're supposed to pay for that without even balking at that. But then, okay, once these people get into position politically, the Muslims, who are, hardcore Muslims, how can you reconcile gay rights, lesbian rights, transgender rights, women's right to a reproductive rights, a right to abortion with these people who are basically saying women don't have the ability to choose this stuff for themselves? How can this all be reconciled? Mm-hmm. Why would we want to introduce that element when they basically everybody hums along pretty decently, minor oppositions. When you got people who are, hardcore set against this, and they probably will do violent actions later if they find something like these.
I actually think that the court contradicted itself in terms of what this judge down there in Rowan County in Kentucky. I think there's a contradiction in terms of what he did. If you're going to have a separation of the church and the state, it doesn't mean that a person has to quit their job like they were trying to say, well, if she can't do the job, let her quit. You make an accommodation. The separation of church and state requires an accommodation to be made if a person has religious ideas that where the person does not carry out in office, carry out a duty that can be assigned elsewhere. You can't assign. This is marriage.
We've been doing this for years. We've allowed the Amish and people who are pacifists to issue. Or
you certainly do.
Yeah. So why is this any different? Basically, she could have her deputy clerks or something sign off on that paperwork. Okay, it's issued, it's duly stamped, it's got the seal of that office. If that really violates her contention, I think she was. I think there is you're exactly right. It's kind of
the law was that. I read Kentucky's law. Kentucky's law, before the court told them that law is not applicable. First of all, there's no law that was violated because the court can't make law. And the law in Kentucky was what Kim Davis was carrying out. The law was what she was doing. The court came in and said that all states must follow the Supreme Court. 5 members of the Supreme Court made a verdict of which 320 million Americans have to follow the verdict of the court. That's not the intention of that's not the Constitution. That's the 5 judges. These people, we have 5 tyrants making that ruling. That's not the court. That's not the Constitution of the United States.
Isn't this kind of a form of ex post facto law? In a way, it kind of borders on that, which is prohibited by our Constitution, ex post facto law.
Yeah, but John, they talk about legislating from the bench. That's not what they're doing. They're not legislating from the bench. If they're legislating from the bench, then where's the law they put on the books? That's not legislating from the bench. They're dictating to us.
That's right. It's basically they're using the power, color.
If you legislate, I got to see the legislation. Then there is no legislation.
They're using color of authority. That's what it is. A color of authority.
They're using a 5-4 verdict, and I can't understand how we tolerate a candidate on the court. He's a swing vote, so he's standing in the middle. He's standing in the gap there. So if 4 on this side and 4 on the other side, the 4 on the liberal side is Breyer, Stephen Breyer. Ginsburg is over there. I think. Well, don't get me started on Ginsburg, and of course Sonia Mayor, and Kagan. Elena Kagan. Those 4, and then Kennedy goes over there pretty much. He's a swing vote, and he goes this way sometime and goes that way sometime. Now we got Roberts over there as a swing vote. The court doesn't know what it's doing because it doesn't have filter to the Constitution. And really, if we were an honest government, some of those, we would have an impeachment process going on with a lot of these people.
Wasn't one president actually reject? He didn't like the idea that the Supreme Court appointees were actually done by a political basis, basically by people. He wanted to avoid that, and he got criticized for that. But I think that would have been a good thing to do, is to make it less political. To make the whole appointment process of the Supreme Court justice less political. And it's political. Anybody denies that is an idiot.
Yeah, political to the core of the government, because the field to the Constitution, quite frankly, is absent. It's DOA, dead on arrival. Those guys are in Washington not following the Constitution. Those guys have disregarded that document. And if we had the rule of law, there would be very few persons that would be standing in Washington as representatives and members of the House and members of the Senate. And it was good. It was a good thing that happened last week, where, and I don't think it's all good in terms of the reason for it, but when Boehner announced his resignation pending at the end of next month, we got to look at the politics. And I have my view of Boehner stepping down has to do with the Constitution, and in this sense, is that the American people found out that we sent the Republicans up there, and the House first, and the Senate, and nothing changed. These guys are still doing they're not stopping this train wreck of the Obama administration. I think that Boehner is a sacrificial, animal that was sacrificed on the altar of tearing up the Constitution, and he's out there being sacrificed. He said it himself that the Constitution, the document, we have to protect the institution. This is what he said. He said protect the country, protect the Constitution. He said we have to protect the institution. These are his words. And so the genie's out of the bottle, so he leaves, and we're supposed to believe what? That somehow reform is going on because the man at the top has relinquished his position. But those gangsters are still there. So we got rid of one of them, 534 remain. What's changed? Nothing. And I think what Boehner is going to do, quite frankly, by stepping aside and announcing stepping aside, he can now do what he had in mind to do in the first place. That is to make a deal with the Obama administration on the budget, to give Obama what he wants in terms of Planned Parenthood, which is a stickler with the voters in the Republican Party, and they're going to make sure that they vote against it. And when the president vetoes any objections that they have, then the government doesn't shut down, because Boehner can go over there with the Democrats and they can side together, and this will be, the government will stay open based upon the fact that that's not going to be it's not going to be taken out of there. The $500 million for Planned Parenthood is going to be put in there. Now, my point is this: it's all a game up there. And if they really had the rule of law, we would have applied Article 2, Section 4 a long time ago against a lot of the members, and that is to impeach these persons and bring about the rule of law. But not having done that, we see that we have this outlaw type of status taking place. Okay, well, we have got to get out of here. I wanted to talk also about another matter, which was this issue of the going to I just heard this morning, going to a currency, a non-currency economy, which is now being talked about with some seriousness. We'll get into that next week, and I want to talk about the implications of that and why that's being discussed. Okay, until next week, we want you to follow your dream, because if you don't follow your dream, you'll never know what's on the other side of the rainbow.